Members, we have already formed a quorum, and I now call the meeting to order. This is the Bills Committee on Construction Workers Registration Amendment Bill 2014. It's the fourth meeting. First item, confirmation of minutes. Minutes of meeting held on the 20th of October 2014. The draft minutes have been circulated to members via paper CB bracket 1/165/14 to 15, and the Secretariat has not received any proposals for amendments before the meeting. May I invite members to confirm the minutes? All right, no objection, then minutes confirmed. Meeting with the administration, that's the next item. Matters arising from a meeting held on the 20th of October 2014. Paper number CB bracket 1/160 bracket 01 and 02. The administration has already responded to the issues raised by members at the meeting held on the 20th of October 2014. That's the second paper that I refer to, CB bracket 1/160 bracket 02. Can I invite the administration to briefly walk us through the paper before I open the floor to members' questions? Thank you, Chairman. At the last meeting held on the 20th of October, members asked a number of questions and made some comments on the levies and registration fees under the CWRO. In paper number CB bracket 1/160 bracket 02, that's our response. Let me briefly go through that. Well, in 2012, we proposed, and it was also passed by this council, the Construction Industry Legislation Miscellaneous Amendments Ordinance 2012. Subsequently, on the 1st of January, the CWRA and the CIC were formally set up and amalgamated into a single statutory body to improve the worker registration system, and also to take up the training of construction personnel. And the most important thing is to make the best use of the resources given to the two bodies. And with regard to the use of the levies, there are several factors for the CIC to determine the fee level. First, with regard to the affordability of the construction workers, and also in determining the fee level, the stakeholders' views will also be considered, and the level has been set at $100 since its establishment. And then for the other specialized trade types, that would be set at $50. And in the light of the financial position of the CIC, well, both before and after the amalgamation, the fee level would not be able to meet all the costs that has been incurred, and therefore a fee will have to be imposed on the workers in order to make up for the shortfall, and in order to ensure that we will provide sufficient services to the workers. We expect that in the foreseeable future, with regard to the registration fee, that would be cut, because we have already extended the registration period from 3 years to 5 years. But then in terms of the use of the money on publicity and also on the workers, that would go up. And that's why, with regard to the worker registration fee, is not able to meet the cost, and therefore we will have to impose this levy in order to subsidize the costs. That's all I'd like to say for the time being, and I'll be happy to take members' questions. Yes, Mr. Sin Chung Kai? I'm reading the paper. I can always refer to the annual report, of course, but then with regard to other spending, you talk about over $10 million. I'm concerned with regard to the registration fee. You will not be able to meet 30% of your cost, but then as the registration fee is only $100, so relatively speaking, it's not very high. But then your expenditure is quite high given the scale of your organization. And after the amendment, you suggest that the registration fee will come under the asset of the body. But then what I'm concerned about is, well, from what I've heard with regard to other expenses, they would be rather high. I don't want to say that you've been very extravagant in your spending, but then the pressure on fee increase will be quite high. So how are you able to control the registration cost? Why do I say that it's cost? Because back in 2013, you talk about some $32.98 million. So it's about $33 million. So within a very short period of time, yes, well, from 2005, 06, and all the way up to now. And if you look at the consumer price index, we're not talking about several folds increase. So let's say that in the first year, the expenditure of $90 million is not that high. Well, that's the starting point. And then starting from the second, third year, how come the expenditure has been going up rather substantially during the past few years? So can you give us some reassurance? Well, given the increase in your cost, will there be pressure on registration fee? Because there is a high incentive on your part to increase the fee. Because for the registration fee, well, according to Annex A of your paper, it will be limited to $23 million, and it's less than 30% of the total cost of the body or the CWRA. Well, in Annex A, actually, we've got a paper, and I think Mr. Sin Chung Kai was referring to the information there. So the information has been set out, and most of the income would come from the levy. So can the administration respond to the questions raised by Mr. Sin? Thank you, Mr. Sin, for your inquiries. Of course, we will not be able to speak on behalf of the CIC, and we are not able to claim that everything has been set up very, very clearly. But then you're right, other than the $100 or $50 registration fee, well, the levy will also form a very substantial part of the revenue for the CIC, and we're talking about 0.03% of the cost, and that has also been set out in the table. That's the levy income. And if there are many projects on the way, then of course the levy will be very high. So that's a very important support or source of revenue. And then if you look at the table, well, from 2005-06 all the way up, yes, you can see that for registration fee, the cost has gone up indeed. And there are several reasons because of the increase in the number of workers doing the registration, because we have now got over 300,000 workers who have been registered, and in the process there are also new registration centers that have been set up, and that would also incur cost, and also the administrative cost, the personnel doing the registration, so that has also gone up. That's why that has much to do with the number of workers doing the registration. But then, as we said last time, when members raised concerns, you were also concerned about the expenses. We have already conveyed that concern to the CIC so that it would look into how it can control the cost, and also in terms of the use of levy, and also how it can subsidize the registration fee and so on. It would be paying attention to that. Yes, Mr. Poon Siu Ping. Of course, from the workers' perspective, they are very concerned about the registration fee, and if it's adjusted upwards, that will have an impact on the workers. So is it that is provided under the law that they will be charged $100, and if they want to adjust it to over $100, they will have to amend the legislation? Is that right? And also, we've been told that upon the commencement of the bill, you need to step up publicity, and you promised last time that you would be stepping up publicity. So in the future, well, under the existing sources of revenue, they would be doing that, and the administration would not be providing further injection into the body in order to step up publicity. Is that right? And according to the information that you provided, if you look at the past registration fee, it will not be able to meet the cost that has been incurred. Yes, you said that in the future there would still be this levy income, but then I think it will also be concerned about training within the industry. So does that mean that if they want to adjust the fee in the future, there is no need for them to report to us, so long as the CIC agrees that, all right, I'll have to increase that from $50 to $80, then they'll be able to do it on their own without coming back to us. Is that right? All right, if we want to adjust the registration fee, we have to do it by way of negative vetting. We have to come back to this council. So we will be doing that by way of subsidiary legislation's negative vetting process. So I said, well, it's not true to say that they'll be charging $100 and then the council will be charging $50.
And if a worker has to register again here, say if an electrician needs another license, then he may have to re-register here. So the levy will be $50. That's what it means. So that's for most of the workers. Most of the workers will be charged $100. As for the levy, under this ordinance, under this registration ordinance, that is for the construction workers registration, the revenue is set out in Annex A. It's not to be paid by the workers. It's for the contractors to, in accordance with the size of the contracts, pay a 0.03% to the CWRA, and that will be part of the cost of the registration fees on the part of the workers. Perhaps I should supplement a little bit. Just now, Mr. Singh asked about the increased expenditure in terms of workers' registration. As pointed out just now, in recent years, the number of newly registered workers has risen. Every year, for the CIC graduates, with more than before. Now we have 5,000 odd graduated trainees per year, and most of them will have to join the industry and be registered. For the construction industry, we can see that some workers have shifted from other industries to the construction industry, and they have to be registered. So the handling size has grown. In recent years, the increase has been caused by other factors. For example, the upgrading of the computers. And in future, when we have a dedicated registration regime, we need to key in more particulars into the registration card. And as we say in the paper, the quality of service will be enhanced. At the moment, the workers may have to wait for a few days. In future, that will be shortened. For example, in Nam Chong Station, we have a new registration center for the new workers. So the cost may be rising a little bit, but at the same time, the service quality is also enhanced. As for the levy adjustment, we have to come to the LegCo. And first of all, a discussion will have to be conducted. And the Hong Kong Construction Association, the staff associations, as well as the Federation of Workers Associations will be represented. And we also have representatives from the trade associations and chambers of commerce. So we have to consider the affordability of the workers when we adjust the fees. And we've agreed on that principle. Ever since 2005, the fee has not been changed. This $100 is not an annual fee. It's a one-off payment. And when the period is changed from 3 years to 5 years, if you do a division, you'll see that it is $20 per year. That's affordable on the part of the workers. As regards operational efficiency, the government and the representatives of the trade unions and trade associations will continue to participate in the exercise. Last time, members raised this mainly because there is this worry that the registration fee may be too high, and whether or not the fees will be subsidizing other administrative expenses of the CIC. And now we know that there is huge discrepancy between the registration fee and the total expenditure of other activities, so there won't be cross-subsidy. And just now it's made clear that if that fee is to be changed, there will be a number of hurdles to overcome, and eventually the LegCo will have to negative vetting, so will be the final gatekeeper. So I hope that has allayed members' worries. If members have no special questions... Oh, you have raised your hand. Mr. Sin Chung Kai, yes? Well, I can see that on page 7 or page 6, the overall expenditure is $500 million. And the two levy together will be $50 million, and levy $46 million about, isn't it? What about the registration fee? About $100 million? Oh, sorry. I was wrong. It should be $9 million. What about the major revenue of the authority? Is it from the government? Well, I think we're on page 6, that is NXA. Well, expenditure, $549 million, right? And the expenses are set out there. And all the levies add up to $50 to $60 million, less than $100 million. So what will be the major source of income for the authority? Well, NXA is about registration, the financial conditions. And then further down, we have the overall expenditure of the CIC in 2013. Well, there is this levy. Well, the CIC's revenue doesn't just come from the registration fees. The CIC imposes 2 levies under the CIC ordinance, and then there's another levy under the Workers' Registration Ordinance. The former is a bit larger than the latter. In 2013, 2 levies add up to $660 million. So what is this levy income in NXA then? Levy income in NXA is the latter, that is under the Workers' Registration Ordinance. Just now I said that there are 2 levies. One is under the Workers' Registration Ordinance. Another one is the CIC levy. And most expenditure of the CIC is spent on workers' training. Huge expenses there. So that's what you mentioned. That is $540 million per year. I'm talking about income. $660 million in 2013. For 2013, the 2 levies add up to $660 million. Well, what about the levy in NXA under Workers' Registration Ordinance? Yes, the levy is imposed on the contractors, and the other levy is also imposed on the contractors, but that is much bigger. Yes, much bigger, 0.5%. And for Workers' Registration Ordinance, 0.03%. Mr. Lee Chao-yan? Thank you, Mr. Chairman. For the construction workers, the majority of the complaints is addressed here. I can see some improvement here. Well, 7 days will be changed to immediately. That's an improvement. So the plus is that more construction workers' particulars can be collected. And then the workers don't have to carry with them many cards, which will be very heavy. So in future, can you gather everything into one card? They have the safety card, which is also divided into two categories. Can you include the safety card into this workers' registration card so that they only need to carry one card? The simple answer is yes. I defer to Mr. Lau for this question on cards. For the safety cards, at the moment, the workers can choose to incorporate that into the registration card. And then under Cap 23, cards have been set out for workers-related issues. And we did talk to the associations concerned, and in principle, they agree that the particulars be incorporated into the workers' registration card. And there are other pieces of legislation under which other cards can also be incorporated into this registration card. So work is underway and work has been quite smooth. So for matters arising from the last meeting, as well as the administration's response to our concerns, if there are no further questions or comments, we'll move on to the draft CSAs. Well, we have several papers here, including 2036-02, 160, 1415-03, and 172, 14-15-01. At the last meeting, members have completed clause-by-clause scrutiny, and the administration has submitted the draft CSAs to us. I would like the administration to introduce the two papers to us. That is the first two of the three that I just read out, and then I'll invite questions from members. Members can also refer to the draft CSAs as well as the marked up version. That is the third paper that I mentioned just now. So those are the reference papers for members. So who from the administration will do the introduction? I think we have a PowerPoint presentation. Yes, that is to facilitate discussion. For the two papers introducing the draft CSAs, we have prepared a PowerPoint presentation, and hard copies of the slides have been distributed to members before the meeting. I'll now roughly go through the proposed draft CSAs. Now, this slide shows you Clause 5.1, amending Section 3.2 of the ordinance. Well, this is actually an amendment to the Chinese text, which is technical in nature. This is to enhance the Chinese text, and the original meaning of the provision has not been changed, and the English text needs not be changed. It's just that we want to enhance the readability of the Chinese text. For example, you propose to delete 在不抵觸, etc., etc. Yes, originally when you read the characters in red, it will be difficult to understand, so we're proposing amendments in blue. For example, 除第 3A 及 4條另有規定外，某些技能是附表1第3欄中所指定 etc., etc. All right, please continue. Well, if members have any questions, they should raise their hand. And then we go through all the PowerPoint slides before we take questions. Well, let me explain. I'll go slowly, and then if members have any questions, they can raise their hands and ask the questions. Now, this is the second draft CSA. In relation to Clause 6 of the bill, we propose to add a new Section 3A to the ordinance. Again, this is a technical amendment aiming at enhancing the Chinese text. The English text needs not be amended. For example, we propose to add in the characters in blue. 凡某建造工作涉及的技能是附表 1A 第2欄所指明的某指定工種分項的規定技能，則 任何人如屬該附表第一欄中與該工種分項相對之處所指明的指定工種分項主要工種分類的註冊熟練技工，即可親自在建造工地進行該建造工作。That means it must be the work types in Schedule 1A before you can personally conduct work on a construction site. Originally, the red characters in the Chinese text are difficult to understand, so the content has not been changed. Well, you have reversed the order. What's originally in front are now at the end. I personally feel that this looks more like Chinese and is more readable. The next CSA is basically the same as the last one, is only in another paragraph. Again, we'd like to enhance the Chinese text. As the chairman said, we're now reversing the components of the sentence. And now, so long as apart from the job types in Schedule 1, the third column, you can conduct the work, and we don't need to amend the English text for 4(1)。
冇意見啊 ？OK， 好，繼續。
No comment. Next, clause 8, section 4A added, and also 1A that's set out in the PowerPoint. So that's again a technical amendment to the Chinese version, and the English version doesn't have to be changed. And originally the wording is 進行涉及以下技能的建造工作. So we change it to 進行以下工作而涉及有關的技能. So I think that will make things clearer. So that's about the skill described in column 3 of Schedule 1, blah, blah, blah. No comment. Move on, please. This time we are amending the English version without amending the Chinese version. That's clause 23(2) of the bill, amending section 45A bracket 8. So that's the blue part in the slide, making it clearer. So that under 23(2) is about the designated trade, and then under 45A8 we use designated trade division because in other parts of the bill is also other trade division. So it's to make it consistent. All right. Please move on. Next, 48(1)B. That's clause 26(2) of the bill. And this is again technical in nature, and in terms of the meaning there is no change. Again, this is to improve the text of the Chinese version, and the English version doesn't have to be changed. So it's similar to what we said. Originally it says 涉及以下技能的, and now we change it to 而該建造工作所涉及的技能是附表1第3欄中與該工種分項 blah 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 的技能. And then under 48(1)B there is another amendment that's in line 1. Originally the wording is 該工人是附表1第2欄所列指定工種分類的. So we think that it's a little complicated, that's why we think that the amendment makes it clearer, and the English version also does not have to be improved, also does not have to be changed. No comment. Please continue. Next, there are two amendments here. The first one is technical in nature. That's 63A bracket 1 and 2. We have added the word "dick" in Chinese to make it clearer. And the second is under 63A bracket 4. We have inserted bracket BA and BB. And as you might have noticed, 63A is for the Bureau Director to make exemption regulation for the relevant parties to observe, and we'd like to make it clearer in order for the avoidance of doubt. That's why we have added in BA and BB. We have made it clear that under the bill with regard to persons who have been exempted, they would have to come under certain obligations. I'll be explaining that in a moment. And then under BB, it says that for anybody contravening the regulation, which is punishable by a fine not exceeding level 3, and at present is $10,000. In other words, if they have breached this regulation, then according to this law, the court can impose a fine of not exceeding $10,000. So the wording might be a little clumsy, so we can also say that you can impose certain obligations on the persons involved. Well, this regulation is to implement the dedicated trade for dedicated personnel, and in implementing this, the contractors or the employer of the workers, they will have to take reasonable measures so that at the construction site, certain exempted trades will have to be displayed. As you might remember, for example, emergency works and also minor works, they would be exempted without requiring the workers to be dedicated workers. So as to what they mean, we will be displaying that, and we will be giving guidelines to the employees as to how they can direct the workers so that they would know that these are exempted work, so that there would not be any confusion on the part of the workers. So that would be done by way of a regulation. But then when it comes to the workers or the contractors, if they fail to comply with the regulation, for example, if they have not given such instructions or directions, then that would be a contravention of the regulation. Therefore, under 4A, they have this duty to comply with the regulation, and any failure would attract a punishment, and the maximum fine is not exceeding level 3, $10,000. So that's for the avoidance of doubt. So we have introduced this. Mr. Sin Chung Kai. So under BA, should it be to impose an obligation, because giving direction is different from imposing an obligation. I hope I've understood it correctly. When you introduce BA, and if you contravene that, that's a direction or an obligation, and if you fail to comply, then there can be a fine imposed on you. So is it that these are actually conditions to be imposed on the workers, right? With regard to imposing obligations, I'll defer to the D of J, who will help me. Yes, our general understanding is that by obligation, you can always flout it because it's just an obligation. So what's the legal definition of obligation? Why have you used this term? Why are you not imposing certain conditions or certain requirements on the workers? Who is to answer this? Mr. Chen? Thank you. The English version is to impose obligations on any person. In other words, there is a necessity on the part of the person, because in Chinese we always call that 义務. In other words, that person will have to take certain measures, and that will be specified in the subsidiary legislation as to what measures will have to be taken, and he has to do it, and we call those obligations. And if there is a failure on his part to comply, then it's an offense. So the subsidiary legislation will be imposing those measures on the persons involved. So that's a very common approach. So this translation is consistent, right? Obligation is always translated into 義務. Well, sometimes it's translated into 責任, but then 責任 would normally be translated into duty. So here you call it obligation, and in Chinese it's 義務. I'm not trying to be picky about the wording, but then it said that who would be regulated under this? Is it the contractors or the workers? Well, whoever is concerned or whoever is involved in such exempted works. In other words, he might be giving directions or instructions to other people to do the work. Theoretically, it's possible that it could be imposed on the workers, but then mainly we are talking about the contractors and also the employers hiring these employees or workers. So would there be circumstances in which even workers would also be required to comply with it. For example, they will have to carry a card to show that they are involved in the work, but then we don't expect the regulation to go in that direction. But then the biggest chance would be that exempted emergency works and also exempted minor works, they will be covered. And if we do not have such specification on site, then the workers would easily be caught inadvertently without knowing. So this will show clearly that these are exempted works and the obligation is on the contractor or the employers, and if they fail to comply, then that would be a contravention of the regulation. That's what we mean here. Legal advisor? Thank you, Chairman. Concerning the obligations and the Chinese translation of Yimo, before the meeting, I've also done some research on other ordinances. I found that obligations being translated into Yimo is pretty common in other ordinances. All right, if it's a common translation that will not give rise to any controversy, then we will be prepared to accept it. Mr. Ip Kwok Him also on this point. Yes, I think the Chinese version is not clear. Now that they've explained, I understand it, but then I suspect for an ordinary man on the street, he may not find it readily understandable. So it's for the workers, you're imposing this obligation on the persons involved, but then as I'm not an expert, I don't know which is the best, what is the best way to translate it. All right, we'll listen to Ms. Chen Yunhan and Sin Chung Kai before we take it further. All right, I've got some specific cases in mind. All right, according to the administration, you said that the employers or the contractors will be caught, but then workers should not be affected. But then when a case is presented before a court, you're talking about persons who are involved in the works. You said that that's not the direction, but then there is a chance that they might also be caught. So with regard to the exemption, so you refer to the exempted works. So can you be more specific about the circumstances under which this will apply? Mr. Sin Chung Kai? Chairman, I don't know if this is a better term. Can we use the term instruction in English, and then you can change it in Chinese correspondingly? I don't know if it's a legal term, but then according to the Deputy Secretary, my understanding is that instructions would be more direct in terms of its meaning. Well, let me explain the differences. All right, as explained, these are instructions or measures to be taken. In fact, they are not very accurate. Because the regulation is trying to say that for persons who are involved in the works, they have a duty or responsibility or obligation to take measures. So there is an obligation on their part to take measures. So here we are referring to the obligation. It's an obligation on those persons to take these measures. So we are referring to the persons who are involved in the works. So can you call it a duty? Well, because in English, for obligations is a more accurate description. So there is an obligation on his part to take these measures. Well, I have to argue with you because by obligations, in English, the understanding is that you're referring to a situation whereby the bureau director has imposed this obligation on this person. All right, you're telling them that I'm giving you these instructions, and if you fail to comply, then I'll be punishing you. Is that all? No, that's not about the bureau director giving the instructions to the persons involved. For example, if he is an employer, he has the obligation to do certain things. For example, certain displays or specifications be made on the site to say that this is an exempted works. So we will explain a bit further later. So he will have to take these measures. And of course, if you suggest that it should not be described as obligation, why don't you call it a duty? All right, we will try to explain the differences between the word duty and obligation later. But then with regard to the persons who are involved in the construction works, and Ms. Chen Yun Han was saying that it's not about the persons who are undertaking the works. We are talking about the persons who are involved in the project. For example, if it's a contractor who has to make the arrangements for these works, and if he instructs the workers to do the work, then he will be involved in the project, and therefore he has this obligation. But then theoretically speaking, well, workers will also be involved in the works. Indeed, that's true. But then our intention is that so long as you're involved, then there is a chance that you may have this obligation. But then according to our thinking, what we're trying to exempt would be emergency works or minor works. They will be exempted. And when we refer to the obligation under the regulation, we are talking about the requirement on the employer and the contractor to do it within the site.
工作，咁我哋睇到咧。
Then we'll see that the work or responsibility rests with the contractor and the employer. What about the worker? Will it be that one day the worker will be required to carry certification with him? If he doesn't do so, there may be confusion. For the time being, we don't think that's necessary. But maybe in future, we'll believe that for the sake of the operation of the construction site, it may be better for the worker to carry certification with him. But that's rather distant and remote. So for the time being, we propose this framework. Ms. Chen Yun Han, I'd like to tell the government officials that, yes, you use the words distant and remote, but for me, that is related. The boss and the contractor have to do something. Sometimes they are being wishy-washy. I'm worried that we may have to wait till a court case comes. You said this is not the direction for the future. I don't believe you. And you said this is rather distant and remote. I don't think so. There may be court cases in future. If you ask me in terms of language and wording, I think you can make further improvement. I don't know whether the CIC has further views. I'm a sensitive person. I'm worried that in future you are placing this responsibility on the worker. Can you make it clearer? That is, the employer, the contractor, and other responsible persons should be specified here. You shouldn't be so general here. I'm a bit worried. Although we don't yet have any case, I'm worried. Deputy Secretary, in fact, in the whole process, when we prepared this bill, we had the participation of the CIC, the trade associations, the employers' representatives, the workers, etc. And now this is about legislative amendment, which is at the highest level. In future, there will be an exemption regulation. We don't yet have the text, but the basic principle is that the exemption will be granted to minor works and specified works. Under the exemption regulation, in future, will the worker also have certain obligations? We're not excluding the workers at this stage. But at this stage, if you ask me, it would be mainly the contractors and the workers, employers that should be tasked with these obligations. For the workers, for the time being, I don't see any obligations to be imposed on them. Will the regulation change anything in future? In future, if there are to be any changes, we shouldn't change this ordinance. We should change the regulation. That is to impose responsibilities and obligations on workers. We're not excluding that possibility. So we would like to make this definition broader. For the participating persons, if we narrow that down to the contractors and the employers, then the contractors and employers may feel that all obligations are placed on them. And in future, if the workers are to breach something, then they may think that is excessively onerous on the workers and contractors. But for the time being, we don't see this as a major controversy. So for the time being, we are proposing this. I can imagine that under an exemption regime, for workers not registered for a particular work type, they may carry out certain tasks, but registered skilled workers guidance will be necessary. So that's an obligation which the workers will have to observe. Maybe this has already been covered by other pieces of legislation. I don't think we should be over worried about this. For those carrying out construction work, they may cover employers or employees. I don't think our laws will propose any unreasonable obligations. Well, Ms. Chen Yunhan, Mr. Chairman, next will be Mr. Sen Chung Kai. Well, Mr. Chairman, just now I asked the administration a question. I asked what happened in the CIC. Just now the government gave me an answer. I understand that in the construction industry, certain things are marginal. Even statutory requirements may lead to trouble. You know that the workers are to wear boots, helmets, etc. But at the beginning of that process, things didn't go so smoothly. Well, for the minor aspects, minor issues, for example, posting up certain things, etc., that may be easier. But for construction workers, most of them don't work as permanent employees. They work as casual laborers. And we have subcontracting. I hope the government will pay attention to what I said. Well, this may not be a major issue, but to reach consensus among so many parties in the construction industry is very difficult. And even for safety issues, you've been repeating and repeating certain reminders, but still, events happened. So I hope that the government will pay attention to our views. I don't want anything to happen in future. I hope nothing will happen in future. But then, when there are really cases, we may have to argue about a lot of things. And workers may refer to me. Well, for the construction industry, under the hard work and promotion of many, many parties, Hong Kong has been advancing. And on certain areas, we are more advanced than others. I mean, other jurisdictions, sometimes vice versa. So I want to say that in Hong Kong, we don't have a stable construction workforce. The mobility of workers is high. So that's what I want the government to know. Deputy Secretary, perhaps I should say something. I understand Ms. Chen Yunhan's concern. I'll pay attention to that aspect. In actual fact, we mentioned this negative vetting process for the regulation. So when we come to that, if any obligations are to be imposed on the workers, members will readily know. And as I said, in the consultation process, we consulted the CIC, the Hong Kong CA, and other stakeholders. Well, this is not really a major aspect, but we'll be very careful in handling it. Well, for the workers' registration system, precisely as Ms. Chen Yunhan pointed out just now, workers don't stick with fixed employers or the same employers all the time. Now we are proposing this registration regime, and we would like it to facilitate the mobility of the workers. Workers with mastered skills can register. So we hope that the workers can play their roles and functions to the full. I think the Deputy Secretary has already heard the worries of Ms. Chen Yunhan. I believe that the implementation of the ordinance will rely on the collaboration of the employers, the employees, and the government. As I emphasized just now, this is an amendment bill. The registration regime has actually attained certain achievements at this stage. So, legal advisor, you've heard the worries. Just now you emphasized that you've done your homework, and you also mentioned that this is the routine way of translation. Will you propose to change the English text as well? That is, to use instruction rather than obligations. Mr. Sin Chung Kai, well, we're discussing language. For honorary duties like honorary secretary, well, if you don't do them, there are no consequences. But given this registration regime, you may be punished if you don't do your duties. As an ordinary person, I don't worry what Ms. Chen Yunhan worries. In future, even if obligations are imposed on the workers, say if helmets are distributed but they don't wear them, they may have to be punished. In future, that may happen. So in future, that is not an obligation anymore. And the workers may argue that that is only an obligation. Well, for an ordinary reader, the Chinese term yi mo doesn't carry any consequences. Sorry, the speaker is not coming through the microphone. And Section 77 of the Construction Workers Registration Ordinance, in paragraph C, the word yi mo is also used in the Chinese text. And the word yi mo, obligation, is not used alone. Liability or obligation of the authority is in the English text, and the authority is the authority. And for the Chinese text, it is 法律責任 or 義務. So in the Chinese text, it's 法律責任, but obligation is 義務. To answer Mr. Sun's questions, if you look at the Chinese term 義務, you have to look at where it is used. In Chinese, in the Chinese text here, we're not talking about voluntary work on which you charge nothing. We're talking about obligations that you have to honor. Under the exemption regulation, if obligations are imposed on you and if you don't honor the obligations, there will be liability and consequences. So it's not your choice whether to do it or not. So Section 77 of the ordinance has been mentioned. This is now clearer. That is the routine way of translation, and it carries legal implications. Well, that may not be the same as what we understand normally in the Chinese language. Well, if we're not in the legal profession, we may understand the term in a different way. As this is a normal way of translation, and other provisions in the ordinance have similar translation, I think we can accept this method of translation. All right, please continue. All right, thank you, Mr. Chairman. The next one is simpler. It's purely an amendment proposed for the Chinese text for Schedule 1A. Under column 1, we add in 工种 to make it clearer. No comments, I think. Next. The next one was actually proposed by the Legal Services Division of the LegCo in June. They asked whether we can clarify the transitional period. That is, within the transitional period, if certain appeal and vetting cases are outstanding, then after the implementation of the bill, those vetting and appeal cases should continue. So in clause 37 of the bill, for section 6, we add in the blue words, that is, request for review and appeal. And then in bracket 2 and bracket 3, if a request for review under section 51 of the pre-amended ordinance remained pending immediately before the commencement date, the request is to be regarded as a request under section 51. And then on the next page, that is for bracket 4 and bracket 5, we spell out the details in relation to reviews and appeals. That is, for the request or appeal, as if the registration and each reference to has effect in that section were a reference to, is to be regarded, and then further elaborated by bracket 5. That is, we handle the applications, but your legal services division pointed out that not just applications, but also reviews and appeals should continue to be handled. Well, I think this is a longer amendment detailing how we should handle appeals and reviews. Legal advisor, any comments?
Thank you, Chairman. Can the administration explain that with the reservation or saving clause for certain reviews or appeals pre-existing or predating this, how will they be dealt with? So assuming that they are pre-existing appeals and review cases, so you said that they would be deemed to have been made under this provision. So that will be dealt with under 39, 44, and 45A. So 39, 44, and 45A as amended. So this sort of review or appeal will continue to be dealt with, but then they will be dealt with in accordance with the amended ordinance. Is that right? Yes, if you look at 39, 44, and 45A, there are some related technical amendments, and there are certain pending review and appeal cases. If they are still pending after the amendment, then they will have to be dealt with in accordance with these amended 39, 44, and 45A, assuming that nothing has changed. In other words, the application for review and appeal will continue to be processed. So they will not be just scrapped or cancelled because of the amendments, right? Yes. Mr. Sin Chung Kai? All right. In Chinese is 覆核要求, and in English is application or request. Appeal is very clear, is 上訴. So for request, is that 要求覆核要求? So is it a request for review? So Mr. Sin apparently thinks that the Chinese version is clearer. So what about the English version? Would that be not so clear? So the first is application, and the next is request. For the Chinese is 覆核要求. So is that a request for review in English? With regard to application, and if the person is not happy, then he can first apply for a review, and then the registration officer would deal with his application for review, and if he's not happy with the outcome, then he can lodge an appeal. So he can apply for a review. Is there a definition or interpretation of the term? We can change it we can turn to clause 39. Is there a definition clause here? Request for review. That's clause 51 of the English version. As a request for a review of decision. That's the English version. And the Chinese version is 對決定的覆核. So it's actually a review. How about the request? The word request. What does it mean? Request for review. Mr. Chen? Thank you, Chairman. If members would like to refer to the original version, that's section 51, 51.1. Those who will be affected by the decision can, within 2 weeks, make a request for review of the decision. And if you look at the entire section 51, so the person affected by the decision will take the initiative to request a review. So that's the wording in section 51. So for any review that has been requested under section 51 after the amendment, and if it's still pending, then they will have to be dealt with in accordance with the amended 51. So all the others will remain the same. But then why do we have to make it that way? Because the trades have been changed. In previously is called designated trades, and now is called designated trade divisions. So they will have to follow the new name in proceeding or in pressing ahead with the request. I understand the procedures. Thank you for explaining to us the procedures. But then in the English version, you call it a request. It's a request for review. There are 2 paragraphs here. Mr. Sin Chong Kai was referring to 2 paragraphs. First, under bracket 6, application, comma, and review. Request for review. Application, comma, request for review, and then appeal. But then I can't find the words request for review. That's on page 10. You're referring to page 12. Actually, that's on 4. Application, request, or appeal. And they have not set out request for reviews. Why have they not put in the words request for reviews? That's on page 10. That's request for reviews. So that's on line 1. It's very clear. Request for reviews. I'm referring to page 11. You're referring to this part? How come we have the word request out of nowhere? I think that's because it's referring to subsection 1, subsections 1, 2, and 3. That's so to simplify the wording. Is that the way to simplify it? Can you turn back to slide 10? Application, request for review, and appeal. So 3 things. It's very clear. But then when you turn to the next page, this is application, request, or appeal. Should it be the same as that appearing on slide 10, application, request for review, or appeal? Well, I'll defer to the legal advisor to see if we have to add in those words. Because if you read the whole thing in terms of the English flow, the meaning is achieved. But then can we put it more clearly by putting in the words review? Well, we will have to look at it. Alright, if we can add in the words request for reviews, then I think that will correspond with the Chinese version. On page, that's slide 11. Mr. Chen? Thank you, Chairman. What we've been doing is to simplify our laws so that it will be easier for a layman to read. And starting from 2001, we used a descriptive way of writing or drafting our laws so that for an ordinary reader, so long as he can read the whole section together, he'll be able to understand it. And therefore, for every subsection, they are all interlinked. So if you read from the first subclause, you understand that the request in subparagraph 3 would definitely be referring to the request in subparagraph 1. In fact, that's the way we put it in many ordinances. For example, for under the Court of Final Appeal, we can just call it the CFA, and then the reader would understand that we would definitely be referring to the court that was mentioned earlier. So if you read the entire provision, then there is no question of reading the individual subsections separately, or else it will become very wordy and cumbersome. Well, originally I was very interested, but then you would actually arouse more interest on my part. Alright, subsection 3, you're referring to requests for reviews again. So how come you're not changing the Chinese version into 要求 instead of 複核要求? So I'm a bit naughty, Chairman. Well, if it does not give rise to any ambiguity or controversy, that's fine. I think there is ambiguity because the Chinese and the English version do not correspond to each other, if that's the way you do it. Alright, if on the one hand you are simplifying the English version, and if you are not doing the same to the Chinese version, then that will give rise to ambiguity. Law draftsman, any further consideration? So we will consider that. So we can see if the Chinese version can also be simplified in order to make the two equivalent. But then the direction is to simplify things as far as possible. But then if you are simplifying the English version, why don't you simplify the Chinese version as well? Yes, I think the Chinese version might be a little wordy, yet is clearer. So I think it's easier to add 2 words to the English version rather than cutting out 2 words from the Chinese version. All right? All right, I'm finishing with regard to the presentation. Page 12 is to delete certain subparagraphs. Yes, because we have already added in the words in blue, that's why the words in red will be deleted. Okay? So you've already gone through the proposed CSAs, and you've also taken on board some of our comments. I'd like to ask a question. Are there any members who would like to move further amendments? Mr. Lee Che-yan, I'd like to clarify this about the schedule. Well, I think that has to do with whether or not I'm going to move my own amendments, because as you are aware, we've been telling the administration that the concrete batcher should also be included. And there's one job or trade division that is about the vehicle, and the trade description is that if they come under one of the following types, and G is the trucks, and for the concrete batcher, would that be covered? Because in the past, apparently you did not intend to include that, but then it looks like that is the concrete batcher. So for concrete batcher or the skip, as we know, most of the vehicles going into the construction site would be concrete batches. We are not talking about those with a crane. We are referring to those concrete batches because they also have a crane and a clipper. Because one of our member unions is also concerned about this. Will that be one of the registered trade divisions in the schedule? Where can we find it? I think it's Schedule 1A. In the middle of it, is about vehicles or work in relation to vehicles. Well, for concrete batches, yes, it was proposed by some trade unions, and under the CIC in the Worker Registration Division, we have discussed with them for a long time on this. So I'll defer to my colleague to respond.
Mr. Lau, in fact, we received from the trade unions under Mr. Lee this request in relation to vehicles related to construction work types. The drivers of those vehicles have to be registered. I think there will be another registration regime for the dump truck drivers. What are the skill requirements for these dump truck drivers? Technically, they may be able to attain the requirements, but for the time being, no consensus has been reached. When we discussed with the CIC and the trade unions, we came to understand that dump truck drivers may have certain requirements on driving skills to be met, but for the time being we don't have a special regime for them. Well, but what about the tippers here? They are part of the dump trucks, right? Well, yes, the two are incorporated. The drivers have to be registered, but they only need to register as truck drivers. But your trade unions want a special registration regime for dump truck drivers. Well, they drive a lorry into the construction site. They are now registered as lorry drivers, not specifically as dump truck drivers. We know that we want a special registration regime for concrete batches. Now, they have another registration name for these tippers. Well, in fact, we did talk to the concrete batch drivers as well. That's another type of drivers. That is, apart from driving, do those drivers have other duties to discharge? And what about these concrete batches? Do they need special skills for driving? We're now discussing and we're to work out the direction ahead. But under this bill, we don't have a special registration regime for concrete batch drivers. Such drivers register as lorry drivers only. Well, Mr. Lee, you're correct. For concrete batch drivers, they actually register as lorry drivers or truck drivers only, and they only need a driving license at the moment. In future, after dumping by these concrete trucks, these drivers may need special skills. In future, we may need another registration regime for these drivers, but we have not come to a final decision yet. Well, during past public hearings, we received some comments on this request. In future, there are further opportunities for amending the ordinance. I think we need to reach consensus on skill requirements and so forth. All right, so we'll consider that. If there are no amendments to be proposed by members, that's it. If any member would like to move CSAs, usually the Bills Committee will invite the administration to respond to amendments proposed by members and the Bills Committee. But for the time being, we don't see such amendments. So basically, the Bills Committee has completed its scrutiny work. I'd like the administration to explain the considerations on the commencement date of the bill. Well, Mr. Chairman, if this bill can be read for a third time in the LegCo this year, then early next year in January we'll gazette the enacted bill such that it will take effect. And the soonest will be the end of February or early March. It really depends on when the bill will be read a third time and passed. Now we have a proposed legislative timetable here. Second reading resumption debate, if that is to take place on the 10th of December this year, we'll have to report to the House Committee on the 28th of November. And deadline for giving notice for CSAs will be the 1st of December 2014. And deadline for notification from the government for second reading debate will be the 25th of November. But if we are to have the second reading resumption debate in LegCo on the 17th of December, report to the HC will be on the 5th of December, and then deadline for moving CSAs will be the 8th of December, and deadline for government notice for second reading resumption debate will be the 2nd of December. So what's your plan at the moment? Perhaps we should work out the dates together with the Secretariat after the meeting. All right. In fact, at the last meeting, we already completed clause-by-clause scrutiny of the bill. Today, the administration has submitted the draft CSAs to us. After the discussion just now, members basically support them, right? There's no objection. All right, so we support the second reading of the bill. Thank you very much. I think we have completed all the existing tasks. Legal advisor, any supplement? Thank you, Chairman. In terms of the latest text proposed by the administration, I received it only today, so I'll study that. If there are any questions or comments, I'll discuss with the administration. By and large, I don't see any need for further meetings. Basically, we've completed our scrutiny work on Construction Workers Registration Amendment Bill 2014. The Secretariat has tentatively prepared some time slots for future meetings. I don't think those will be necessary now. So once again, I'd like to thank you. Any other business? None? Meeting adjourned. Thank you very much, government representative.